Hello and good evening, everyone. Thank you for joining us this evening. My name is Diana Cervera, and I am the Education Program Manager for California Lawyers for the Arts San Diego office. Welcome to today's webinar, Cross-Border Migration, Family Law, and Mediation, where you will gain valuable information from tonight's expert panelists. I know many of the folks in the virtual audience tonight do important work here along the border region and beyond, so we are very excited for you to join us for this important conversation today. Before we jump into our workshop, as many of you know, California Lawyers for the Arts is a statewide nonprofit organization serving the arts community by providing a number of legal and educational services across the state. To share a bit more about our programs and services, I'd like to play a short video from our Executive Director, Alma Robinson, who will share more about our organization, our history, and opportunities for membership. Thank you for being here.
Hello, my name is Alma Robinson, and I am the Executive Director of California Lawyers for the Arts. CLA is a statewide nonprofit organization that was founded in 1974 to serve artists and arts organizations of all disciplines with advocacy, as well as services that provide support with legal and business issues. With staffed offices in San Francisco, Berkeley, Sacramento, Los Angeles, and San Diego, we provide several core services. First, we provide legal counseling to specialized attorneys who provide assistance with a variety of intellectual property questions, as well as contract reviews and negotiations and other important business issues. Depending on the client's financial status, legal assistance may be available on a pro bono or reduced fee basis. We also provide a specialized program that assists independent inventors and small startups with their patent applications. To help with situations involving disputes, we provide a range of alternative services, including negotiations counseling, mediation, and arbitration that can avoid the expense and hassle of going to court. Finally, we offer a full menu of educational programs that include workshops, symposia, and conferences on various legal topics for artists and arts organizations. Many of these programs are posted on our YouTube channel, and we encourage you to use these tools to educate yourself on the legal issues before you reach out for specialized assistance from our organization. Thank you for joining today's program, and please consider joining CLA on our website at www.calawyersforthearts.org so that we can continue to maintain our full range of services. Thank you.
Once again, thank you so much for being here with us. I'd like to go ahead and get us started with our workshop. And so without further ado, I'd like to introduce our guest panelists, Melissa Kucinski and Carolina Martin Ramos. Melissa Kucinski is an attorney and mediator with her principal office in Washington, D.C. She has served as a consultant to the Hague Conference on Private International Law in 2013 and has written a dozen articles published in more than one language on international children's issues and mediation of complex cross-border custody and child abduction cases. Melissa has presented at over 30 national and international conferences on international children's issues and mediation. Melissa has traveled to Tokyo twice for meetings on the Hague Child Abduction Convention, first in 2014 as part of a US delegation, and again in 2019 at the invitation of the Japanese Ministry of Foreign Affairs. Melissa has been a long-standing member of the US Secretary of State's Advisory Committee on Private International Law. She served as a private sector advisor to the U.S. delegations, the Hague's 6th Special Commission meeting in 2011 to review the practical operation of 2 international children's treaties, and she attended the 7th Special Commission meeting in 2017 with International Social Service. Her newest book, Family Law Across Borders, Cases and Comments, was released in July 2021 by West Academic. Welcome, Melissa. Thank you for being here. And our other panelist is Carolina Martin Ramos. Thank you also for being here. Carolina Martin Ramos is co-executive director of Comunidad Maya Fishim Ixim and directs the Mayan Human Rights Program and Legal Services at CMPI. Carolina is an immigration and human rights attorney with years of experience in nonprofit, government, and private practice. She has worked on immigration issues in criminal law, non-citizen victims of human trafficking, and crimes, with special recognition for her work with rights of Indigenous migrants and LGBTQ asylum seekers. Currently, Carolina focuses her work on the rights of Indigenous peoples through pre-existing indigenous traditional laws and governance, and international human rights mechanisms. Through her work, Carolina has responded to multiple legal and humanitarian crises related to the forced displacement of indigenous peoples under colonial state policies, including environmental destruction through extractive projects and industries. Carolina volunteered at the Red Owl Legal Collective at Oseti Sakwin, Standing Rock Nation, and worked with asylum seekers at the US-Mexico border region during the surge in 2014 and subsequent events where caravans of asylum seekers faced human rights violations, family separations, and refoulement under the Trump administration's zero tolerance policies and the MPP program. Welcome, Carolina. Thank you both so much for being here. Without further ado, I'll turn the floor over to the two of you. Thank you so much.
Gracias, Diana. Thank you.
I'm really excited to be here, and I'm even more excited to be with Carolina. It is a great pleasure to have someone who is so skilled and has the background of an immigration attorney, because that is something I lack completely. So if you see me stumbling over those questions when we go through our slides, that's certainly the reason why. I'm Melissa. I'm the family lawyer of the two of us. And I promised Carolina that I would take the lead in at least doing the read through of the slides so that we can have a robust discussion. We're going to be asking questions of each other and of ourselves. And we intend to go through some real life fact patterns and even propose additional facts as we go through all of our slides to try to give you a solid understanding of what these issues are for cross-border families. And I'm sure Carolina will echo this. They are horribly complex and often confusing. And at times there are no legal remedies for some of these families. And so it gets really, really complicated as we go through. So hopefully we'll instill a lot of that complexity in you so that you can help move things forward when you're working on these cases. Before I turn the slides, I want to make sure Carolina doesn't have anything further to add.
Thank you. No, I mean, it's really an honor for me to be able to, have been speaking with you and preparing for this presentation and learning from you, Melissa. It's a real honor, everything that you've done, in terms of international work as well as your family law practice. And so, as someone who has not focused on family law and has never practiced in family law courts, these intersections areas are where there are really interesting issues that come up, but I certainly don't attempt to tackle, the family law issues because they are highly complex, especially when they intersect with immigration laws and other international human rights mechanisms. And so I would have to go to an expert like you, where the Hague Convention and other issues came up that I wouldn't be prepared to deal with. So it's really great to be able to put these things together.
So I think it's probably time to get started. We're going to go through some fact patterns. So I'm going to go to the next slide. I'm going to read this, especially if it might be hard for some of you to read, depending on what device you're looking at the presentation on. So this is our first fact pattern. Karen and Hector are parents to one child, Manuel. Manuel is age 5. The parents are separated. They live close to one another in their home country of Honduras. The parents do not have a formal court order that dictates Manuel's custody, but he tends to live primarily with Karen and visits with his father, Hector, on weekends and holidays. In September of 2020, sort of suspending disbelief because of COVID, Karen agreed that Hector could travel with Manuel to the coast to visit Hector's brother. The trip was scheduled to last approximately 2 weeks. After approximately 1.5 weeks, Hector called Karen to let her know that he and Manuel were in Mexico and were about to cross the border into the United States. He was asking Karen to sign a document he had prepared and emailed to her that gave him custody of Manuel. Karen pleaded with Hector to bring Manuel home, and then their call was disconnected. So Karen contacted the U.S. Department of State 2 days later after she attempted to, but could not reach Hector on his phone again. They advised her that she may be able to request her son's return to Honduras using an international treaty called the Hague Child Abduction Convention. They send her a form to fill out and advise her that she will need a lawyer in the United States once they're able to locate where in the US Hector and Manuel are located. So this raises a whole host of a lot of questions going forward. So I'm going to start by taking you through some of the international family law questions that might come up. And then Carolina is going to go into some of the immigration questions, and then we're going to reconvene and see where they may overlap a little. So the fact pattern indicates that there is an international treaty that allows for the return of children from one country to another country when a parent has unilaterally removed the child out of their home country and taken them to another country, or while they're in this new country, perhaps they're there for a vacation or a limited time trip, and they decide to retain or stay in that country for an extended period of time without the other parent's permission. So there is this international treaty. It is the law in the United States. We ratified this treaty in 1988, and a variety of other countries have also ratified this treaty. This treaty is only in place when it is actually law between the two countries. So there are status tables on the Hague Conference's website, and specifically the US is not a partner in this treaty with every single other country that has this treaty in place. So it is very important that if you think that this particular treaty might be implicated by a cross-border family, that you double check to make sure it actually is law between the United States and the other country that's in the particular dispute. Honduras is one of those countries. This is law between the United States and Honduras. So Karen, who is sitting in Honduras, might be able to use this particular treaty to return her son to Honduras, his home country. That is all it ultimately does. It doesn't resolve his custody. It doesn't necessarily put the child back into her custody. All it does is return some status quo to this particular family. It doesn't decide custody jurisdiction. So it doesn't say what court in what country actually ultimately has the authority to resolve custody of Manuel. It doesn't dictate travel or passport laws or options for this family. It just is that status quo type of situation. So after it resumes that status quo, the family can keep arguing and disputing in whatever's the proper place for them to do so. So Karen may try to use this treaty. She initiated the process by what is a typical first step, which is she contacted the US Department of State. The US Department of State is the office in the United States that's designated as what's called a central authority, and they accept requests from parents for children who are in the United States, or even requests from parents in the United States whose children may have been taken outside of the United States, and facilitates having this parent apply for resources to try to seek the return of their child. The US Department of State has a lot of great resources in that they can exercise all of these federal government databases to try to figure out where the child is located in the United States. So they're probably going to help Karen do that because she's not sure where in the very vast United States Hector has Manuel. And they might be able to help her locate a lawyer, although that's not a guarantee. And they might be able to help her provide free or low-cost interpretation or translation if she needs that help in communicating with the lawyer that she finds. And they might be able to help provide her some resources, information on where she can go to get more resources in the legal field, in legal aid, in the court systems, and things like that. So they can provide great resources, but what they don't do is they don't go into the courts in the United States and actually file the lawsuit that's needed to ask for the child to come back to Honduras using the Hague Abduction Convention. That is going to be all on Karen. She is going to have to locate a lawyer, hire a lawyer, and use that lawyer to file a lawsuit. And she's going to have to file that lawsuit in the specific courthouse in the location in the United States where Hector and Manuel are now sitting. So it's very important that she locate them in the United States, because in our country, she could conceivably file in any state or federal court, but it has to be the one where the child is actually sitting now post-retention. When Karen gets to that point in her case and she files a lawsuit, she's going to have to prove a few things. And I could go on for all 2 hours on these legal concepts, but just to give you a very basic overview, she's going to need to pin down the date that Hector actually wrongfully removed Manuel from Honduras and brought him into the United States. She's going to have to prove that Honduras was Manuel's habitual residence, or his home, his center of life. She's going to have to prove that she has a right of custody under Honduran law. And that could be a variety of different things. There's no custody order. So it's going to have to be a process where you have to engage a Honduran lawyer to actually opine on what is Honduran law and whether she has this custodial right. And then she needs to show that she was actually exercising that right of custody at the time that Manuel was removed from Honduras and brought to the United States. Hector will then have some arguments to try to prevent Manuel from going back to Honduras under this international treaty. He specifically can argue that Karen consented for him to bring the child into the United States, or that after they got to the United States, she acquiesced by some formal written document. He could argue that Manuel was mature and objected to returning to Honduras. However, he's only 5 years old, so that's probably not likely to succeed. If Karen waits a full year or more before she files her lawsuit in the United States using this treaty, then Hector can actually argue that Manuel is now settled in the United States and should stay here. He could argue that Honduran law violates human rights, and therefore he shouldn't have to return his child to a country where the human rights are violated. Or he could argue that there's a grave risk of harm to returning his son to Honduras. That could be anything from inadequate medical care that won't help this particular child and their needs, educational resources available in the United States that are never available in Honduras, that this particular child has that need. Or it could be something like abuse, domestic violence, gang violence, or a variety of other things that could happen in the home country to the child, not necessarily to Hector, but to Manuel if he were returned. It's a very high burden. That's the most commonly argued reason for why a parent saying a child shouldn't be returned to their habitual residence, their home country. But it is also a very, very high legal burden to be able to prove it. And routinely, there are what you or I might consider very unsafe conditions to return a child, but the child is nonetheless returned with the expectation that a custody case would then go forward in that home country and that court was well equipped to take care of the child. So now that we got that pinned down, let's talk a bit about the immigration issues.
Thank you. Yeah, and I'm really interested in learning more about those exceptions. And if I can just ask a question in between, is I think the burden would be clear and convincing evidence that he qualifies under an exception. Is that right?
So it depends on the exception, but the most argue in the grave risk, which is probably going to be the most overlap with the asylum issues, that is clear and convincing evidence, which is quite a high burden.
Thank you. All right. So let's look at some of the immigration issues that are arising in this hypothetical. So, what ways can Hector and Manuel legally enter the United States when they arrive at the US-Mexico border crossing? So there are multiple ways. We don't really have all of the facts, and since both the immigration law piece and the family law piece require a lot of factual analysis, I'm just going to make some up. So, for instance, they may arrive at the port of entry, at the Mexico-US port of entry, and already have some type of visitor visa and a tourist visa B1, B2, and Manuel may have actually gotten that visa previously because he knew he was going to take the child, and so he's able to enter with this, what we call a non-immigrant visa. Another thing that they could do when they reach that border is, of course, they could enter without inspection, which is the irregular way to enter the United States and would violate immigration laws and policies and would also make them deportable. But of course, many folks do it that way, especially when right now a lot of non-citizens are stuck outside the United States because of Title 42 restrictions and the Migrant Protection Protocols, or MPP programs. Another way is that they could present themselves to the Border Patrol at the port of entry and explain that they're seeking asylum, that they need protections under international human rights laws and under federal asylum law. Of course, again, with the reality right now is Title 42. Even when they assert those claims, they may be turned away. But generally what they're supposed to do and what happened in the past is that then the Border Patrol agents, if they asserted that they had a fear of return to their home country because they would be persecuted or tortured or killed, which is also considered torture, then the Border Patrol officials are supposed to not violate this international law concept called refoulement. There's this idea of non-refoulement, like we are not supposed to send people away to their death, especially when they could face state-sponsored persecution and torture. And so the Border Patrol officials would then be obligated to either parole them in or to take them into custody. First of all, they would be detained by the Border Patrol at what a lot of people refer to as las hieleras, the cold, very cold, terrible places where people are held while they're initially processed by Border Patrol before they're transferred into DHS or ICE detention centers. And then they would, potentially have to present their claims and prove that they are eligible for asylum and meet the definition of refugee under international and federal immigration law. And they would have to do that before an immigration judge in the EOIR immigration court. There is a possibility when they get to, say, Tijuana, that they start communicating with an attorney and are able to get humanitarian parole, but I don't know that we have facts that would really support that. But those are just, some of the ways that they could enter into the United States once they got to the border from Honduras. So if Hector Emanuel requests asylum, what does the process look like at the US border? What forms are completed? What verifications must they make? So again, if they request at the border, Border Patrol will be the first point of contact if they present themselves to Border Patrol, but also if they enter what we call EWI, enter without inspection, and then look for Border Patrol agents to take them into custody and process them, or they are snagged or arrested by Border Patrol agents. Se las agarran. And entonces, so what will happen right there is then when they're detained, they're going to have to go through this process where first of all, they'd be processed by Border Patrol, but then they have a right to go through what's called a credible fear interview. And in some cases, folks are only eligible for a reasonable fear interview. I'm not going to go into, the differences in those, but generally folks that, haven't previously been deported and don't have criminal convictions would be able to go through the credible fear interview process with an asylum officer. And so the asylum officers who conduct the credible fear interviews are actually highly trained. I myself was an asylum officer in the Los Angeles Asylum Office. And so most of the asylum officers I worked with were former immigration attorneys. Most of them worked in a nonprofits. So they were actually immigration advocates and cared a lot about trying to grant and protect people under these international mechanisms and under the Refugee Convention and laws. And so the credible fear interview would be conducted. If the asylum officer gave the person a positive determination, then that person would be able to continue to be detained by ICE and then present in front of an immigration judge. This is the only time really in immigration law that people are trying to get in front of an immigration judge. Once you're already in the interior, you're probably trying not to get into deportation proceedings and before an immigration judge. But if you're an asylum seeker, you really want to be put into immigration proceedings and be able to present your claim in front of an immigration judge, because otherwise then CBP and ICE can just, affect an expedited removal and deport you really quickly, or just send you back across the border or send you to your home country. So hopefully, if Hector Emanuel pass or get a positive determination on this credible fear interview, then they will be able to present their claim before an immigration judge. In the case of the child, though, the child is going to be separated from the father probably, unless they're in a family detention center. And so how that child will be treated in the case, sort of depends. But anyway, if they do get this positive determination and they are going to be able to present from an immigration judge, they can also request a bond. They can reach out to their deportation officer and ask about bond, but they can also ask an immigration judge to give them a bond. If the immigration judge gives them a bond, then they would be released from the detention center, and then they would present their claim to another immigration judge in a different court for the non-detained cases. So just really quickly, there are really two forms of seeking asylum. One we call defensive asylum, the other is affirmative asylum. asylum. So defense of asylum is for people who have come to, the attention of the sort of law enforcement arms of the Department of Homeland Security, Border Patrol, ICE. And so they have been charged with violating immigration laws. And it's like when a DA files criminal charges against you, the DHS law enforcement have charged you in the immigration court with these violations. And so you're forced to, defend yourself against an ICE attorney before an immigration judge and really prove that you have a viable claim and that you meet the definition of a refugee under the law, versus the affirmative process where, say, Hector and Manuel enter the United States with a tourist visa. Then once they come in, inspected and lawfully that way, they can go straight to the asylum office in Los Angeles or any other asylum office in their jurisdiction and apply affirmatively. They will submit what's called a Form I-589, which is the same form that they would submit before the immigration judge, but they will be submitting that to the asylum office of USCIS, and it's a less adversarial process. And so they will, instead of having to fight against an ICE attorney in court in this adversarial system with judges that deny over 90% or over 80% of the cases, they will be able to present their case before an asylum officer in an office suite. And it's a completely different experience. And depending on your jurisdiction, like in San Francisco and Los Angeles, the asylum officers grant more than 80% of those cases versus judges that deny 80 to 90% of the cases in places like El Paso. So verifications that have to be made, if they're in the defensive posture, of course, ICE and CBP are going to, want to take their biometrics and determine who this person is. And then that will happen in a different way in the affirmative process, but they still will be investigated to determine, whether they, have committed crimes or are persecutors themselves in, other jurisdictions outside of the United States. And then they will have to gather, the type of evidence they'll need to present to either the immigration judge or the asylum officer so that they can demonstrate that their eligibility, and that burden, of course, is on them. So what happens to Manuel's claim for asylum if a U.S. court requires him to return to Honduras before he is granted asylum or after he is granted asylum? So Manuel, the child, is probably, with his dad and their attorney, has filed their I-589 seeking protections under international and federal immigration laws. However, if the mom is challenging under the Hague Convention and has gone to federal court, and the federal court has decided that he was wrongly taken from Honduras and his mom, and he needs to be returned to Honduras, then the problem that could come up in terms of his asylum case is when you're asserting a claim to or grounds for asylum and your eligibility for asylum, you're saying that, like, do not send me to my home country because I am, almost certain to be killed. I will suffer persecution, torture, and you have to provide all this evidence that you would in fact suffer persecution or torture or death. And so if Manuel is sent back to Honduras and he's totally fine and he suffers no threats and there's no persecution, there's no evidence of all of that, it kind of, his own asylum claim crumbles, right? Like, then it's like, well, he doesn't really need the protections in the United States. If he's granted asylum in the United States and mom's still trying to get him returned to Honduras, then, I think this is one of those cases where it's kind of depend on what the federal court decides. And so how I've in the research I've done, and Melissa, please jump in and help me with this. But, it seems that when this has been an issue, and I've seen, I guess people have written about in the Fifth Circuit in particular, that there have been, they've looked at it more as sort of a competition between the Hague Convention, right, international law, and federal asylum law, or laws that fall under the INA, Immigration and Nationality Act. And so they're looking more at this sort of competition between these federal domestic laws and international laws. For me, as a former asylum officer and somebody who does international practice, I don't understand why, when I look at the research, why within the federal court there isn't sort of an argument about, well, what trumps the Refugee Convention, which is also, an international human rights convention, or the Hague Convention. But I think that, it's going to depend.
I envision that's going to be coming down the pipeline at some point in cases.
Yeah, and I think it depends. I think people are trying to ask judges to use discretion because this is largely a factual type of analysis and have to consider the best interest of the child. But the judge is really going to have to grapple with sort of concepts about rights and protections from family law as well as international law and federal asylum law. So I think we just kind of have to see where this is going.
So if the judge in the Hague abduction case does not return the child, deems that there is some appropriate reason under the treaty to not return the child, do you think that might positively influence the asylum case?
Well, it could if, for instance, the reason the child's not being sent is, because he falls under this exception that you mentioned earlier of, that he would face some type of grave harm. For instance, a lot of the cases where children and parents, unaccompanied minors, but also children traveling with their parents are coming from Honduras is because they're fleeing gang violence, because the gangs basically are de facto government in parts of Central America, including Honduras. And so, if they were able to present this evidence that sending this child back would get him killed by the gangs, that's, that would definitely support, his maybe an asylum claim around, being a member of a particular social group. Or, also if there's domestic violence, if the dad's able to show that mom, is violent towards the child or abusive or something, that could be another way that would support his claim for asylum.
Right. And there have been courts in the United States that have addressed that in terms of Hague abduction cases, both the gang violence and the domestic violence issues. So the gang violence, I've seen that consistently courts have seemed to narrow in as, is this particular child most at risk based on the facts before me to be conscripted into a gang when they're returned or to be harmed? Or is it just a very general threat that there is gang violence in that particular country? So this child, when he goes back, if he follows the pattern of other children there, is more likely to be conscripted into a gang. And I found that the courts are more likely to find that there's a grave risk if it's very specific to this child, but not if it's very general to this, to this particular country. So it's a very, very specific and, like we said, a very high threshold for that particular exception. Also for domestic violence, that's a very, very common argument that the parent in the other country is a violent parent. But then we get into analyzing, well, the child doesn't necessarily have to go back to that parent. They're just going back to their home country. And is that home country equipped to protect that child? Do they have systems in place like foster care systems? Do they have courts that can issue a protective order to, prevent the child from being harmed by that parent? Has there been a custody case started in the home country so that there is some arrangement so that they know that that parent might have only supervised access with this child? And then there's the whole other layer that if it's the parent, the taking parent, so Hector in this particular situation, that was the survivor of the domestic violence or abuse, and he says, I am not going back, even if Manuel was not directly abused or subject to the violence. How does that play in? And does that affect whether or not there's a grave risk nonetheless to Manuel to return without his father deciding to go back voluntarily? Now, there have been a couple other questions. One, does a child's rejected or denied asylum case count as a strike or a ding on their record as far as unlawful entry for the future and then follow them into adulthood?
Okay, so it's a little bit mixed up because unlawful entry, IWI, and unlawful entry into the United States is different than having your asylum claim denied, right? So if I enter the United States and I, present this whole asylum claim before an immigration judge or something, and I, don't win my case, my petition is denied and I'm removed or deported, that doesn't mean that I can't seek asylum again in the future, because circumstances could change, the political situation in my home country could change. I could come back and I might have a stronger case. I might have a strong enough case this time or not. But certainly if I have a deportation on my record, it's going to depend again on sort of the circumstances, but it could mean that I'm not, going to be eligible necessarily for asylum asylum, but I may have to try to seek protection under the Convention Against Torture, or CAT. And so, like Melissa mentioned earlier, that there are these different sort of burdens of proof. And so for someone who, is going through a credible fear interview, it's sort of like easier to get through that and pass that, because the burden of proof isn't as high as maybe, or the things you have to prove aren't the same as what you'd have to prove in a reasonable fear interview. Or for instance, in immigration deportation proceedings, where you're trying to gain protections through asylum and the Convention Against Torture, it may be easier to prove your eligibility for asylum, but then you've got these other sort of hurdles to pass if you're going to try to get protection under CAT. Like under CAT, you're going to have to prove that it was like state-sponsored persecution or torture or violence. It couldn't be just a non-government actor who the government was unwilling to control necessarily. It's a little bit complicated, but so I don't know if that answered your question, because I didn't really understand the question. It seemed a little bit like mixing up a couple of things. And there's another question that says, can the mother be attached to the asylum case? How is custody and visitation affected and realized for mom? And Melissa says, you're going to answer that?
So the custody and visitation. So to the extent that I'm understanding this question, the first thing I'm looking at is, well, where is custody and visitation actually going to be resolved? And under the facts that we have for Hector and Karen right now, because Hector and Manuel came into the United States unilaterally and they haven't been here that long, it's going to be resolved in Honduras, assuming that Honduran courts say, yes, we have the authority to do so. It can't be resolved in the US state where they're now sitting, at least not right away. There have to be a lot of circumstances that occur down the line, duration of probably at least 6 months, no court case pending in Honduras, the child's not returned to Honduras under the Hague Abduction Convention, and then just a whole lot of factors that would need to essentially align. All the stars would need to align for them to be able to deal with a custody issue here. So in that regard, of course, you're going to a courthouse in presumably Honduras, at least in the initial stage of this particular family situation. And I'm sure Karen is going to argue that the father of her child is an abductor. And so it will be up to the judges to determine whether or not that plays some type of role in whether or not Karen gets custody, and there's a court order that's issued by the Honduran court that could be brought to the United States and attempted to be enforced here to return the child separate from the Hague Abduction Convention.
And I guess there was sort of a two-part question. The first part was can the mother be attached to the asylum case? And so I'm assuming what you mean by attached is, can she benefit under the asylum application or petition that's submitted by Hector for himself and Manuel? Generally, if they have this adversarial relationship and have legal claims against each other, that's not going to happen. And, so if mom wants to seek asylum, she's probably going to have to seek asylum on her own and present, that she actually is eligible.
Is there any difference between seeking asylum in the US when you're coming from Mexico versus some other country like Haiti or India?
Well, I think this is a really great question, because it gives me an opportunity to sort of explain something that I hear people misunderstand a lot in the general public, and all the talking heads on the news always misunderstand this. They're always like, oh, why don't those people do it the right way? Well, they are doing it the right way. If you read asylum law, it's like how you seek asylum. It's written in black and white law is you have to present yourself at a port of entry or be in the United States. You can seek benefits. There are different refugee benefits that you can seek outside of the United States, but it's not the same thing as asylum. Both require that you prove that you meet the definition of refugee under international law and domestic law, but it's a different process. There are different officers who adjudicate those cases. And so when you're talking about asylees, it doesn't matter whether you're coming from Haiti or India or Mexico. The actual sort of individual rights under those laws, and the process is supposed to apply the same ways. So whoever's knocking at the door at the port of entry should be all sort of treated the same. Now, when you're actually in the process, I will say that, unfortunately, what we see is a lot of our immigration laws and asylum laws are very political. And so it's going to depend on the US's relations abroad. So, for instance, you might see that when folks from Venezuela are coming to the United States, or even when, white Cubans came to the United States and we had the wet foot, dry foot policy, there was a different sort of opening and willingness to help or give temporary protected status or TPS, or, to view those folks more favorably or treat them differently. And unfortunately, the truth is, at least from my experiences, these are my opinions, but what I have seen is that, we just saw how Black Haitians were being whipped by Border Patrol on horseback, like the slave patrols. And we see, all the time how Indigenous and other folks from Mexico and Central America have been treated. So, technically under the law, people should all, we're supposed to be, these laws were created to protect people because we never want to see another Holocaust, because we never want to see that type of human suffering again. So they should be applied to people from Haiti or India in the same way that they would be to other folks. But there are also some other things that come up in the asylum law process or in the process of applying for asylum. So the idea of, can you be returned to a third country, or, where Mexico and Canada are right on the border of the US. There's just some other sort of technicalities that come up, but generally speaking, it shouldn't matter.
Okay, so there was some crossover, as you could see, from between asylum claims, the fear of being returned to the home country, the grave risk of harm exception under the Hague Abduction Convention. So I guess what information from the respective cases sort of cross-pollinates with the other cases? And I heard some mention of, say, was there a visa application? Would that visa application actually have to be signed by both parents? Or could a parent fabricate a signature? I know at least for a US passport for a child, if the parents share legal custody, legal decision-making authority over a child, both parents have to apply for that child's US passport. There's very limited workarounds in that way. So, are there papers that have been filed or presented, and what do they say? Who signed them? I mean, that's what I might be looking for. And then I know you mentioned things like there might be an interview. I, as the family lawyer, would say, well, what came out of that interview? Is there an assessment, a form, whatever that might be that comes out of that? And what does it say? If I were representing, say, Hector and wanted to make out some type of grave risk of harm argument to the child. So, that might be what I'm looking for from your asylum case if I'm trying to work on my Hague abduction matter.
Yeah. And there is a report. There is the asylum officer, after conducting the credible fear interview or the reasonable fear interview, will, make this determination, but they have to back it up by, law and facts. And so there is a written decision. But of course, in cases where, like asylum cases, humanitarian cases or like human trafficking cases, the information can be so sensitive that it's not, necessarily, that easily available. But for Hector, of course, he would get a copy. And if he chose, along with, his attorney, to present that to demonstrate that he qualified under the exception or an exception, then he could do that.
And the other two questions on this particular slide have some way touched upon questions that our participants have already started asking. What is the impact on the actual child? And I actually represented a minor child that was brought from a different country into the United States by one of her parents. And there was a claim for asylum for both the parent and the child when they're entering. That's the extent of what I knew. The person who was the immigration attorney for both the parent and the child then chose to represent the father in the Hague abduction case that the mother then pursued against him for having wrongfully brought the child into the United States. And I then came in as the child's attorney, and then there's a whole bunch of ethical issues related to this lawyer who was representing both and now is only representing one, and whether their issues, diverge. But, as the child's attorney, even though it was in a limited scope in this Hague abduction case, which is not a custody case, which is not meant to decide what's best for this child, there was still something weighing on my shoulders about, well, what does happen if I advocate that this child needs to go back under the Hague Abduction Convention? Does that have some significant impact on my child client if, say, this child wants to ever come to the United States again in the future? What might be that type of impact? Or on the parent, there was some argument, whether it was valid argument or not, that the parent's asylum claim was actually stronger by having the child with him in the United States versus if he entered alone without the child. I don't know if that's accurate, but there was also that argument by his lawyer that he, when we were negotiating, that's what needed to happen.
Well, I mean, to me, that just sounds like a conflict of interest for that attorney because, he needs to consider the child's interests, as much as his client, as the child is also his client, as much as he does the parents, interests. And it sounds like he's really prioritizing the parents' interest. And so, of course, this has come up, and it's treated different in different jurisdictions under immigration law. So for instance, as I mentioned, I'm board in the state of New Mexico. And I think it was when I was still actually practicing in New Mexico that, there's this whole body of law with these decisions around ethical rules. And in this case, it was basically saying that, you can't really represent, say, families or husband and wife, both of their interests. If I'm trying to do an adjustment of status and get a green card for a non-citizen who's married to a citizen, it's like you kind of have to pick, like, who are you actually, dedicated to? And then, it's not uncommon for those cases for then, you're sitting there working to get, legal permanent residency for the non-citizen who's married to a citizen. And then all of a sudden you start getting calls that there's been an argument or there's domestic violence. And, at least under the case law, under that body of case law in the state of New Mexico, we were not able to, effectively represent both parties without engaging in some type of conflict of interest that could harm them.
And then the other argument that I often hear in Hague abduction cases is, I brought our child into the United States because we previously discussed that the whole family was going to move to the United States. So we're just going ahead. We thought you were going to join us. And of course, then the parent in the home country always says, no, that was never the plan. I was never going to join you. And I certainly wouldn't have agreed for our child to move there unless I was with the child. So, what if Karen does want to join Hector and Manuel in the United States? What if that really was their plan? And you indicated earlier that she may have to file her own asylum claim or her own separate individual petition of some sort.
It just depends. It was sort of like based on the way that the question was posed previously. Mm-hmm. But certainly there are times when people are able to receive a grant of asylum in the United States, and then they're able to, bring family members to follow, if they're eligible and meet, the specific eligibility requirements. But, there are different ways. And I just think it's sort of like we have to think in terms of a spectrum, which is why all of the facts are so important, right? And I guess when they're presented, all the evidence and facts, when it's presented before these federal judges to consider, because you might have cases where it's like parents are, in Honduras and there's a lot of gang violence, but maybe the parents disagree about what's best for the child. One parent thinks it's best to stay in Honduras and the other parent is adamant that no, we must get them out of the country, right? Or you could have cases like I know you and I talked about, Melissa, where there is like female genital mutilation, what we call FGM, and maybe not picking on dads, but maybe dad and his mother are adamant that girl child has to undergo female genital mutilation as part of their cultural tradition, and mom is in some way expressing, I don't know, what might be considered feminist opinions or against the FGM, and decides to what they would consider abduct the girl child and bring her to the United States for protection. So there's really a spectrum, and there are a lot of facts and things to consider. I have never had to litigate this in federal court the way you have around the Hague Convention, but I would hope that FGM would be considered an exception.
Well, see, that might fall under the grave risk of harm exception. And then the question would be, what is still in that home country to protect this child? I mean, the father might want this child to undergo this procedure, but is that something that is supported by the laws and that the laws would allow it to happen? Or were there laws in place that would protect this child, that this child was nonetheless returned? So there's a whole dynamic right now. And actually there's a case where a parent requested a petition for cert before the US Supreme Court that we're still waiting to see what they'll do, if they'll take it up based on this grave risk of harm exception. It was based on domestic violence in that particular case, but the trial court kept ordering the child back to Italy in this particular case, despite the court finding that there was a grave risk of harm. And it was because in some of our jurisdictions within the United States, but not all, the case law has developed where these courts are mandated to look at whether or not there exists certain protective measures in the home country that would nonetheless allow them to return the child, even if there is a grave risk. And so they're going to see, well, we'll all see if the US Supreme Court decides to take that up and decide whether that extra step is going to be mandatory on courts going forward.
Yeah, and I would just say that, it's a very similar analysis in terms of a lot of humanitarian benefits in immigration law. So where we're trying to get what we call T visas or T non-immigrant status for trafficking victims, likewise, we have to show that look, if you remove this person, if you don't give them that protection, you don't allow them to remain in the United States and be protected, and you send them back to their home country, for instance, in Mindanao, an island in the Philippines, there are, basically traffickers or these contract people that go down there and seek out Filipino women to take them to Qatar and Saudi Arabia and subject them to human trafficking. And so, and is the government of the Philippines protecting them or not, right? And so you have to provide that type of evidence to explain why, look, if this person gets deported, this is the evidence that shows that, they're likely to be killed, trafficked, or whatever. So they're similar sort of concepts and ways of analyzing and arguing.
And there was a recent case just earlier this year out of North Carolina in a Hague abduction case. The mother actually presented as evidence her credible fear screening paperwork from her when she entered into the United States from Honduras seeking asylum. She presented that paperwork in the Hague abduction case, but then when she testified, it was inconsistent. And the judge then found her to be lacking all credibility and said, well, then there is no grave risk of harm. I hear what you said to the border. You either lied to them or you lied to me. And it really did some damage to her case.
Well, and that's the problem that we see over and over again with asylum, right? I mean, you get people who, asylum seekers are basically refugees. They are completely in crisis. Many folks who are at least, showing up at the southern border seeking asylum, like you see in the caravans or recently with folks from Haiti. And, if you this is where the trauma-informed approaches have to come in, because if you have suffered significant trauma, you're trying to negotiate harm. You're sort of in this state of PTSD or something, and you're trying to negotiate harm. So when you come into contact with CBP or Border Patrol, these law enforcement agents, the immigration officials, you don't know that you can really trust them to tell them your asylum claims. And it's sort of more like, oh, don't hurt me. I'm a good person. I just want to work. I want to do well for my children. And so then what happens is then when they get before an immigration judge, the immigration judge will say, oh, well, now you're saying that you were being persecuted for your political opinion or activity. But when you talked to Border Patrol, you said you just wanted to get work here. And aren't you really just coming here to get a job or something? And, that's where the credibility, and all those things come up. And it's really sad to see that, we should really make sure that everybody, including judges, are really, understanding the process they're going through and how trauma impacts people, how PTSD impacts a lot of these folks.
Absolutely. So one of the questions we had was, would Hector have to prove that Honduras was detrimental and not that the U.S. is in the best interests of the child? Is there a standard in a Hague case, or is that for the court and the jurisdiction of the family court case? So if Hector wants to argue against his child going back to Honduras, he only has those very limited exceptions that I've already delineated, and one of them being a grave risk of harm, that the home country, the habitual residence, would present a grave risk of harm to his son Manuel, not to him, Hector. The Hague abduction case is absolutely not a best interest analysis. They are not concerned at all through the presentation of evidence as to what is best for a child, because the presumption of the drafters of this particular treaty is that what is best for a child is for them to be back in their home, and for that the proper court with jurisdiction to issue a custody order, and for that court to do the assessment. So presumably, if under the Hague Abduction Convention, Manuel does get returned to Honduras, it certainly is going to be the Honduran courts that do this best interest analysis and determine what is the best custody resolution for Manuel between his parents. And then
the immigration attorney, as the immigration attorney, I'm going to be really concerned that, is Manuel going to face persecution or torture? Is he going to be, harmed? And one thing that I'm going to have to also prove is, for instance, I'm just going to give another sort of example, which changes this hypothetical, but in a lot of cases of, say, transgender women who are fleeing persecution and torture in Mexico, when the immigration judge is considering whether they can be returned to Mexico, Mexico is considered a large country geographically. And so the judges, or probably the ICE attorney, is going to say, well, didn't you just suffer persecution in Jalisco? But, there's, all these other states in Mexico you can go to, and you can get away from your persecutors. And so, as Melissa had stated, that, then that person's going to have to show that, no, that harm really exists throughout Mexico, throughout the country. And also that, for instance, the Mexican authorities, government actors are not going to protect them, that it's not just, police in Jalisco, that it's, really the Mexican government and society in general is not going to protect them. Now, when you're talking about smaller countries, a lot of times you don't have to really argue that as much. Like if you're saying, El Salvador or something, the immigration judge, and everybody sort of agrees that, oh, that's a smaller place. It's harder to, hide out in some other part of that country.
What if the protective legal measures have been exhausted and failed in the home country, and the risk of harm or abuse still remains? Do courts consider the failure of the systems to protect the child? And so I think that's probably related to the Hague Abduction Convention. I mean, it's going to be a case-by-case, family-by-family analysis for these judges in these courts. So it's going to depend on a whole host of factors. Yes, maybe there's failings of systems in the home country, but maybe that there are other things in place. Maybe it's not the fact that their legal system might be corrupt or incapable of issuing a quick order to protect a parent or a child, but maybe there are relatives in that home country that could help protect the child. Or maybe the family in the home country has money and the ability to afford to protect the child. Or maybe there could be some type of arrangement or agreement that could be enforceable in the home country, where the parent that's still there gives money so that the child doesn't just return alone, but that the parent who brought the child to the US could also return with them. So there's a whole host of considerations that are going to be very tailored to this specific family that might not even be related to the country themselves and whether or not they have the ability to protect the child. It really is that this child, the default is they need to go back. In fact, there's a particular article under this international treaty that gives the court, the judge in the US, the discretion, or the judge, whoever's hearing the Hague abduction case, the discretion to return the child no matter what. Doesn't matter. You could prove any of the exceptions and they still have that discretion, that authority to return the child.
Wow. So what happens a lot, there are a lot of cases, especially that come out of Central American countries, is that folks will come up and the asylum officer, the immigration judge will say, oh, well, you're saying that these gangs were threatening you, or you say you suffered from domestic violence. Did you report that? Did you give the authorities an opportunity to investigate and protect you? And a lot of times people will say, no, I didn't report it to police. And then they're going to ask, well, why not? And generally people will say, well, that's a ridiculous question if you're from where I'm from, because you would know that the police are corrupt and they work with the gangs, or, because of machismo or whatever, because of the culture, like, women and children are protected from domestic violence. But it's not going to stop there, because then they're going to have to provide evidence and demonstrate that that's really true, that it's not just something that they think in their own head. That be like, how do you know that the police are corrupt? Well, because I watched when my father handed them a bundle of money every month when they came seeking their quota, or and then you're going to also want to have like international country conditions reports to back that up. So it's not as simple as just saying, hey, it's just not possible in my country. You're going to really, it's going to help your asylum case if you can show that you did exhaust those remedies and that you did try to do those things and you still couldn't get protection and help in your home country.
So moving on from poor Hector and Karen to another poor family.
We really stayed on them all the time.
In this particular family, the mother and father are Colombian. They used to live in the United States, but at present they're at home in Colombia. They have 2 children, both born in the US, both US citizens. During the children's spring break from school this March, the mother traveled to Florida for a vacation with both children. She entered on a tourist visa, but then she never returned to Colombia. The father later finds out that she and the children have settled in the Washington, D.C. area. She's not in status. What options does the father have? So we now go back to the international family law issues. We already talked about the Hague Abduction Convention. He could certainly, if Colombia and the United States are treaty partners under this treaty, which they are, he could pursue a lawsuit in the Washington, D.C. area and whatever court, whether it's D.C., Maryland, Virginia, whatever court, state or federal, that they're sitting in, so that he could ask that the children come back. He would have to prove the certain things that we discussed already, and the mother would then have certain ability to argue those exceptions, those limited exceptions. The other option, of course, is that assuming Colombian courts are the proper place to resolve custody, which under these facts, it would appear they are, he could get a court order from the Colombian courts. And in the United States, every single US state has a form of a uniform jurisdictional act when it comes to custody. Under this particular act, we treat foreign countries as almost as if they're sister states with limited exception, which we don't have enough time to get into, but for the purposes of this, we'll say that it doesn't apply. He could take that Colombian custody order, and it's a fairly straightforward process where he can file it in the courthouse, the local courthouse where the mother and child or children are sitting, and then ask that it be enforced. And there's very limited, even more limited than the Hague Abduction Convention, very limited exceptions that the mother can then fight to have that not enforced and not have it registered. Things like she didn't have due process or the opportunity to participate in the proceedings in Colombia, that maybe it's not a final custody order, or maybe that Colombia didn't have jurisdiction over the children in the way that we would deem jurisdiction as to be appropriate. Very limited. You don't get into the grave risk of harm. You don't get into assessing whether the Colombian courts might have done the wrong thing, or that Colombian law might look a little different than our custody laws. For the most part, in 9 out of 10 or more cases, it is going to be registered and enforced formulaically. So now we're narrowing the options. This family is here, and the Hague Convention had certain arguments relatively narrow. Now it's going to be an even more narrow second option. And you could do either or both. You could file the Hague abduction suit. You could also get the Colombian custody order and register and enforce it. You could do both simultaneously. You could do them both in sequence, but there are now multiple options. So what does the other alternative look like for the father? Perhaps if he doesn't need to seek or want to seek his children to come back to Colombia and he's okay with them living here, he might then, after a certain period of time, once DC or whatever jurisdiction in the US has, the time has elapsed that it has now become the home of the children or the home state under our jurisdictional law, then he might file a lawsuit in the appropriate US court and seek some type of custody order, which could include him having access in the United States or in Colombia or wherever he may want to live or be at that time. So again, the father now has an additional option, which may have been available in the other case as well, but just adding to our toolbox when we're having this discussion. So what about the immigration issues now?
Let's see, what are the father's options to enter the United States? Well, it sounded like he could possibly get a tourist visa, right? Without more facts, it's hard to know. He could certainly come in the ways that I mentioned before, that any non-citizen can enter the United States, can enter without inspection, but then they would be subject to deportation, and they could come in on some type of what we call non-immigrant visa. Tourist visas fall under that category. Non-immigrant visas really are, meaning that that person is not trying to adjust status to be a legal permanent resident. And then immigrant visas are for people trying to be legal permanent residents, or a more permanent type of status that has different and probably broader rights. So for any court case, I'm not really sure I understand.
Right. So an argument that I get all the time is say the father wants to initiate this Hague abduction lawsuit in the United States. Well, sometimes you can participate remotely. What if he wants to be here in person for that court case, especially if he feels confident he'll succeed and he wants to just take the children back home right at the end of the court case?
So technically, what we have always been told, and under the law, is that if you have an order from a judge, his attorney in the United States could get an order from the judge for him to appear in court. Technically, he's supposed to be able to show up at a port of entry with that order and be admitted. What I've actually seen, because most of my clients are folks of minimal resources, is that, you may or may not, that a lot of times the Border Patrol could just ignore it, laugh at you, turn you away. But if he is a person, say, coming from Colombia, who has some amount of economic status and power, social status, it may be easier for him to just use that U.S. judge's order to come into the United States. And then for relocation to be closer to the child, again, that's just really going to depend. I mean, what is he eligible for? Immigration is really about visas, right? Immigration, people always conflate it with criminal law, but it's not criminal law, it's administrative law. And so I like to describe it as really like a form of licensing. So like when you are seeking, a driver's license, well, what kind of driver's license do you have? Are you allowed to drive a motorcycle or a commercial truck, or like what show me your license and I'll know what rights or what bundle of rights you have attached to that license. And likewise, visas are like, well, what rights come with a tourist visa? What rights, tourist visas don't give you the right to work or be employed in the United States. Is it a student visa? Is it a J visa? Is it legal permanent residency? They all are different types of licenses with different bundles of rights. And so depending on, his eligibility for, it sounds like for relocation would mean something more like an immigrant visa, legal permanent residency. He could certainly, wait until his children became US citizens and turned 21, and then they could apply for him, or he could, apply on his own, or maybe he's got other family members and he could do a family-based petition. It's just really going to depend on the facts. And then what are the mother's options to remain in the United States? Again, that's going to depend. I mean, she has come in on a tourist visa, but if something happened in Colombia, she was, persecuted by the government or the FARC, or I don't know what, she may be eligible for asylum. She could, since she isn't detained by Border Patrol or ICE, she could submit a I-589, with the asylum office in her jurisdiction and apply for asylum along with her son. If there was some type of domestic violence, it's not going to work in this case, really. She's not going to be able to get a U visa, because if the domestic violence occurred in Colombia, that's not going to make her eligible for a U visa, the domestic violence would have to happen in the United States. I don't know. I'd have to have more facts when people come and get an immigration consultation, they give me a lot of information and facts, and then I have to try to figure out which boxes they might fit into. I may be able to tell somebody, hey, you're eligible for VAWA visa, you're eligible for a T visa, you're eligible for U visa, you're also eligible for an asylum visa. Now, here are the different sort of caminos or ways to approach those and get those, or apply for those, or petition for those benefits. Which one do you want to do, or do you even want to do more than one? And then there are times that that people give me a lot of information. I have to say, yeah, you don't fit into any boxes. There's nothing that you're eligible for. That's just the way it works.
So what happens if the father enters legally, he takes up residence in DC, but then he refuses to reconcile with the mother and she remains out of status? I mean, do you envision problems? I mean, from a custody perspective, it's interesting. One would think immigration might play a larger role in custody cases than I've seen it play. It could play a role with how stable a parent is, if they might be deported at any moment, how that impacts the child. In this particular family situation, the children are US nationals, so they're allowed to stay here. So that may put an argument forth that if they are both located in the DC area, but one parent is here legally and the other is out of status, that the parent who's here legally might be a more stable parent for the children to be with. So you could certainly argue that in a custody case if that was ongoing here. But I have not seen judges take that, into account at a very high level, unless there's evidence that the parent who's out of status is an imminent threat of actually being deported. Most of these parents would hopefully come into a custody case in the US well prepared with their immigration attorney to be able to say to the judge, no, they've been meeting every appointment, they've been applying, they're eligible for this particular way to stay in the United States, and I opine as the immigration attorney that they have a good, reasonable likelihood of being able to stay here legally. And presumably, if you can present that type of evidence, the court would disregard the fact that they might not have the same legal status as the other parent.
Well, for me as an immigration attorney, just looking at the question, I'm wondering how long has Dad been in the U.S. after he entered lawfully, because maybe his visa was a tourist visa that it was only effective for 6 months, so maybe he's already out of status as well. My understanding as somebody who doesn't practice family law is that it shouldn't matter unless there is some real threat to the well-being of the child. Certainly where parents are detained, sometimes courts have to decide who's going to take care of those children. But I have read about cases where there have been perhaps anti-immigrant judges, I can't say why they decided this way, that actually took custody away from parents because they didn't like the fact that the parent only spoke Spanish to the child and refused to try to learn English. I don't know if you've read about those cases, but I always find those pretty horrifying. And even during the family separation that we saw, under the zero tolerance policies, there were parents who, some of those kids, I worked with some of those families, and I went down to Maya territory in Guatemala, and a lot of those parents might be monolingual Maya language speakers from rural areas. They didn't know how to find their children or reconnect with them. And now their children were, first in the custody of the Department of Homeland Security, and then later transferred to, the children's HHS and the children's shelters. And some of those kids, in that really messy process where there wasn't effective documentation, they were sent to foster homes, some were adopted out. Just there are opportunities for some really horrible things to happen, I think. But I am not in the family law area, but have you seen that too, Melissa?
I always say that it depends on what the judge ate for breakfast as to what they're going to do in a particular case for a particular family. I mean, they're human and they have their own biases, and certain courts in certain parts of the country certainly have different political leanings. Some judges in some jurisdictions, even for family courts, are elected. in Washington, D.C., where I practice, it's the president of the United States that appoints our family court judges. So it's a very interesting dynamic depending on where you are in the U.S. for family courts. In terms of the second question, for a Hague abduction case, does immigration status ever sort of impact that argument so that the father might be arguing it's more important to have the children return? I mean, the father's argument in Hague abduction case in this family scenario is very limited. He just has to say, Colombia is the habitual residence of the children. I have a right of custody under Colombian law, and I'm actually exercising that right of custody. That's all he really has to prove. It's the mother's burden to then prove that one of the exceptions applies. If the father delays and doesn't file his lawsuit within 1 year of that child being brought into the United States wrongfully, then the mother can argue the children are now settled here in the United States. And that's where I've seen immigration status come in these Hague abduction cases more often than not, is that is a child actually settled here if their immigration status might be impacting that ability to be settled, that they might not be here tomorrow. And so that's where I see that most. Okay, so I think this is our last poor family for the evening. Javier and Marcela are parents to two daughters, ages 14 and 11. The parents met in the United States. The family resides in the United States. Their daughters were born in the US. They're US nationals. Javier is Guatemalan and Marcela is Mexican, neither parents in status in the United States. One evening, Javier says that Marcela flies into a rage. She's angry. He came home late from his job. She throws a cell phone at him. She screams at him. At one point, she runs at him carrying a knife. He leaves the house, waits a few hours, and then comes back to find the daughters home alone. He sleeps on the couch. Marcela does not return that evening. He's concerned about her being dangerous, and he would like to secure custody of his two daughters and preclude her from returning to their apartment. So this brings up an issue of a civil protective order. Our family courts or parts of our courthouses throughout the United States do offer this type of protection. It varies state to state as to what protections precisely you can get, but there's often two elements to these types of orders. If you can prove whatever it was that the harm existed under whatever your statute is in your state, you can typically get some type of restraining order saying that the other person can't come within certain distance of you, can't communicate with you, can't connect with you. But these orders often also can include provisions for temporary custody of the children, or could even have provisions that the other person, the other parent, has to stay away from the children as well. It also might be able to include some type of family or child support in the actual civil protective order or restraining order. And in this particular case, Javier might want to consider pursuing that. However, as I've often seen in these cases, in family cases, it's often he said versus she said, or, whomever is on opposing sides. And it's often when you file a civil protective order, the other person countersues you, also requesting a civil protective order. And now you're having competing arguments against one another. There's also the opportunity that often in these cases, they settle, often on the day of the actual hearing, with what is called consent protective orders, where they arrange some type of arrangement with the children, an arrangement for staying away from one another. The question is depending on the US jurisdiction, whether or not consenting to a protective order is essentially consenting or admitting that you committed this bad act, which in many jurisdictions in the US is a crime. That you often have to have committed a crime in order to qualify for a civil protective order. So if you're admitting essentially either by consenting to a protective order or going through a protective order hearing, I certainly would be interested in knowing, are you actually having some type of finding from a judge or, admission that there was some type of criminal activity, depending on how, what level, misdemeanor, felony, whatever it might be. What happens if Javier takes the children to Guatemala to keep them from Marcela? I mean, this comes into not just the Hague Abduction Convention, but also in the United States, it is a federal crime to take your children to another country and to keep them outside of the United States, away from the other parent that's in the United States. So long as the children have been in the United States, even for a brief period of time, if you're then taking them out and holding them outside the United States, that is that federal crime. There's a lot of implications with that, but it can be very complicated because, you have to convince a federal prosecutor that this actually is not just a family matter and a family dispute, that it really is a criminal act. The prosecutor needs to then take up the case and obtain some type of warrant. Then you need to see if there's an extradition treaty with the foreign country in order to actually pursue extradition of that parent back to the United States. The extradition treaties, even if there is one, might not cover parental kidnapping. If it does, then at best you can get that parent and extradite them back to the United States, but it's only extraditing that parent. It's not extraditing the child. The child might still end up sitting in that foreign country. So, Javier might be subject to a Hague Abduction Convention case in Guatemala. He might be subject to criminal sanctions if he ever wanted to return to the United States, or if there is an extradition treaty with Guatemala. And what if he's concerned that Marcelo might actually take the children to Mexico and keep them from him? Now we're getting into the issue of abduction prevention. And the biggest issue is that we in the family law field say that the United States has no exit controls. What we actually mean is that if one parent shows up at the border to exit the United States with their child and the other parent is not there, no one is going to say, oh, do you have the other parent's permission to be leaving the United States? So it is relatively easy to exit the United States with your child, just one parent without the other parent's permission. The only way to really prevent that is to get a very solid, well-drafted custody order from a court in the proper jurisdiction that prevents that parent from removing the child from the United States, and then getting a copy of that order to the U.S. Department of State, which also translated to Customs and Border Protection. CBP actually has a program called Prevent Abduction, and some refer to it as Prevent Departure. It is essentially a program where they can maintain this custody order that you got. They flag you in their system. If you show up at the local international airport to leave the country, or at a border crossing, there is a notation of this in their file. So if the child is with that parent seeking to exit the country, in more cases than not, they will catch that and they won't let the child to exit the country because there's that prevention measure. There's also a passport issuance alert program. As I was saying earlier in the program, in order to get a child a U.S. passport, both parents, if they have joint legal custody, need to both sign for it. That doesn't stop some parents from lying on applications and trying to get the passport nonetheless, so that they can take the child and leave the country. And the U.S. Department of State has a program where you can enroll your child in that, and you are alerted if the other parent or anyone actually applies for a U.S. passport for your child. That doesn't stop foreign passports, though. Foreign countries have sovereignty and they can issue their passports themselves under the rules that they dictate.
Wow, I'm learning so much from you.
Same.
I had a case where there was domestic violence, and it was two non-citizens. Neither of them had status in the United States, and one of the parents fled outside the United States and took the U.S. citizen children and one non-citizen child out, and the mother was not able to get them back, even though she had an order from a judge, and the DAs got involved. The U.S. attorneys, I don't believe ever, got involved, but there wasn't much that could be done once they had left. It was pretty bad. So anyway,
even if there are laws, they don't always function.
Right. Yeah. And then, there are those countries that we know that don't protect people from domestic violence, or, that women are persecuted, or children, and things. So, children don't have the same rights as adults and things. So trying to get authorities in other places to get involved might be hard. All right. So immigration law issues. What options does Javier have in the United States? So if Javier came to my office, I would want to know, probably first of all, like, hey, when this craziness went down with Marcela, did you call the police? Because if he had reported this to the police, then I'd say, let's get the police report, and now let's start working on applying for a U non-immigrant status or U visa for you. Marcela is also a non-citizen, but not a legal permanent resident. So he wouldn't qualify for a VAWA, what we call a VAWA visa, where he could be a self-petitioner and gain legal permanent residency pretty quickly through that. But if he had reported to police, he could be eligible for U non-immigrant status or a U visa. I didn't see that in the facts, so he's probably going to say no. And then he's going to say, but I'm working with Melissa. She's getting me, a protective order, civil protective order. And I'm going to say, well, if Marcela violates that order, report it to the police right away, because then, we could possibly pursue the U non-immigrant petition or U visa. What other options? I mean, if he's been in the United States for less than a year and he has some type of viable asylum claim, we could look at whether he could apply for that. Other than that, I'm not too sure. His children, his U.S. citizen children, would have to be 21 to petition for him. And this is the saddest thing. I always have people who come to me and they say, Abogada, I'm so happy. My my U.S. citizen born child just turned 21. I'm ready to adjust status. And then I have to ask them questions and they tell me, well, I say, how did you enter the United States? Oh, well, I entered irregularly, or I entered through the river or the mountains or the desert. So I entered without inspection, i.e. weed. And then I have to break the news to them that although your child is your immediate family member and, they're not going to be able to apply for you to gain legal permanent residency or adjust status to be what we call an LPR, because you were never inspected. You did not enter the United States lawfully. If, for instance, this U.S. citizen child happens to have some extreme hardship where they've got, cancer or, some other maybe medical issue, and they really depend on the non-citizen parent to get them to their doctor's appointments and take care of them, then maybe we can apply for what's called a provisional waiver, do an I-601. In that case, under the Obama administration, the parent or that citizen within the United States, but then once we got that approval, they would still have to leave the United States. It's like, well, go back to the beginning because you didn't do it right the first time. You didn't come in and get inspected. Now you've got to go back and you're going to have to be inspected through the consulate or the Department of State, representatives at the consulate or embassy in, say, Juarez, Mexico, for instance, if you're Mexican, and then go through that process. And then, there's always this chance that even though before you left, you were told that, yes, your provisional waiver, basically has been approved. If you don't get through that interview, if the consular officer says, well, I think you're a drunkard, or your tattoos look like gang tattoos to me or something, you could end up stuck outside of the United States and not be able to come back in. So perhaps, the parent, could do that. But again, they'd have to wait until that U.S. citizen child is 21 and of age to petition for them.
This particular fact pattern, it resonates with me because I do have a lot of clients like this that would come to me and they express concern. I don't want to file for a civil protective order because I'm afraid. What happens if I am found to have committed something, even though that's a lie? Does that impact my status or my ability to seek status in the United States, or will I get deported because of it? Or likewise, if I get a custody order that says the other parent can't take the child, but then I'm filling out formal paperwork with Customs and Border, protection on behalf of my child, am I in some type of system then that I'm going to be concerned that, all of a sudden it's going to alert them that they need to deport me? So, I get those questions often. Of course, I don't necessarily have answers to them, but it's a huge concern.
Yeah, no, it really is. And the problem is that things change.
Mm-hmm.
And, previously, now there's some movement. People are suing USCIS for not adjudicating those cases quickly enough. But say, for instance, with the U visas, you could file for a U visa and it would take 5 to 10 years or something before you got an answer. You're just like waiting there out of status. And so, what happens though is that, for instance, prior to the previous administration, the previous Trump administration, I had applied for clients we'd done petitions for U visas or T visas, right? And generally USCIS would say, and was the Vermont Service Center is where USCIS adjudicates those types of very special petitions. And they would say like, okay, well, you can apply for a U visa or you can apply for a T visa. And if we don't approve your visa, and as long as you're not some like terrible threat, some type of, terrible criminal or, violent criminal or something, we'll just deny the petition, but don't worry, we're not going to pass on your information to ICE. You're not going to get deported. You're not going to be put in deportation proceedings. And then all this, so I told people this, that not to worry. And because that was what immigration's, attorneys told people. And then all of a sudden we had this administration that suddenly came in and changed the rules and said, no, if your U visa is denied or your T visa is denied, and we don't care if you're a trafficking victim or whatever you claim to be, if it's denied, we're going to put you into removal or deportation proceedings. And then in terms of just reporting to local law enforcement, it's, you want to be able to tell people that, like, yes, don't worry, the police are there to protect you. You can report to them. They shouldn't take you into custody, and they should take your report. And even if they don't investigate or, aren't really, interested in providing you with much protection, they shouldn't try to take you into custody or send you on to ICE or give your information to immigration authorities. But honestly, you have to be really careful in the jurisdiction that you're practicing in, because like I've practiced in the state of New Mexico, I've practiced in different parts of California, and it really is very different. And it really, even within the state of New Mexico, it depended on, are you in Albuquerque or are you in Raton in the north? Which county are you in? And is that sheriff really anti-immigrant? Even, when I was practicing, or I was in Northern California, in Oakland, California, which the Bay Area is considered, to be generally in the United States, a pretty safe place for immigrants and certainly non-citizen victims of crime. There were, sheriffs that were known to be anti-immigrant, and, immigration attorneys had to advise people that they might have to be careful in reporting that they were victims of crime, which is this terrible thing to have to admit to, that's the reality. But, I have heard stories of people who've come to me and said, like, hey, I was reporting that I was a victim of crime, and then suddenly the police arrested me. And I've seen victims of domestic violence that are detained by local law enforcement, and even trafficking victims who are, charged with crimes, whether it's, prostitution or violent crimes or drug crimes. And the underlying criminal conduct was all related to their victimization. So it's folks need attorneys and attorneys that are going to be able to advocate and work this stuff out for them and get them out of those situations. I don't know what else to say. It's a sad state.
I think that's probably the best takeaway, at least from this slide as well. What can people say or not say? Should they be filing certain complaints? What do they need to be worried about? As you're saying, it changes. You need to talk to an attorney. You need to not necessarily rely on legal advice that you or your friends have gotten, especially if it was a long time ago. You need to talk to an attorney now, for good or bad, whatever those resources are. Okay, we're closing in on about 10 more minutes. So I think we have just 2 more substantive slides. We wanted to touch upon the ethical issues because, especially since they've been coming up already. And when they came up in our earlier part of the conversation, we were talking a lot about immigration lawyers also representing people in family court cases or Hague abduction cases and vice versa, whether they're representing both parents and children simultaneously, and whether or not create some type of conflict because of the case or the person or the issue, and whether it's diametrically opposed to the other issues or the other positions that they need to take on behalf of the other clients or in the other case. So that's a huge issue. The other, of course, that comes up is often unauthorized practice of law. Immigration law is federal law. Hague Abduction Convention is implemented in the United States through a federal statute, but it is applied differently depending on where you are in the United States through case law, because the treaty itself actually doesn't even define its key terms. And if the US Supreme Court hasn't weighed in on what the definition of a key term is, then you're stuck with whatever a particular jurisdiction is. So if I were to be handling a case that's a Hague abduction matter in a jurisdiction where I'm not actually licensed, such as with local counsel that has admitted me for the purposes of that case, I would have to do significant research, because even on this federal issue, this international treaty issue, it could be applied extremely differently depending on where I'm sitting. And then in terms of cross-border cases, I mean, family law is state specific in the United States. You can only practice where you are licensed. So you need to be very cautious when it's a family that touches upon a lot of different jurisdictions and they're very mobile and they're moving around and they have all these complex issues, that you're not inadvertently crossing some type of ethical line in order to, try to help them and give them advice. Then, of course, we come across the competency. I think that's probably self-explanatory. As we were talking through today, I realize how little I know about any of the immigration issues, and they come up in so many of my cases. So I need to make sure that I'm not trying to opine on something that I'm not competent to opine on, and I need to get them to Carolina or, an immigration attorney that's local to me that might be able to work on the case simultaneous with me and side by side and advise me when I have those questions and make sure I'm not stepping over any issue that needs to be addressed in a different way. When we're talking about scope of representation, we're talking about, well, what case are we actually dealing with? Is it the immigration case? Is it the Hague abduction case? Especially if you're representing them in multiple matters, you want to make sure that you are very clear and communicative with your client. They might not speak your language as their first language, or they might not speak it at all. You might be speaking through interpreters. You need to be very clear on these very crazy, complex issues that this family might be dealing with. And the jurisdictional issues alone, I mean, I have trouble describing those to lawyers, let alone someone who is not a lawyer, who is a client of mine. So I need to make sure that when I'm describing these complex issues, I'm really giving good advice that's clear to this particular client and their circumstances.
Yeah, and I would just, say in terms of the scope of representation, I mean, that is, people coming from different legal systems might not, understand. I always tell clients like, hey, or even family members trying to ask me for legal advice on housing or something. I'm like, hey, that's like asking a foot doctor to operate on your heart. Like, we really do sort of, focus on our own particular areas. I don't know very many people who can do several areas particularly well. So to ensure that I'm not violating the rules of professionalism and ethics, you can refer to the ABA model rules and your state jurisdiction. I would make sure to be competent that I would consult with Melissa or consult with a family law attorney in the jurisdiction that matters. But with scope of representation too, I have to be really clear with my clients. And sometimes I have to say it more than once. And even though it's in the contract, right, I have to go back and pull out the contract again and refer to it and go, no, I'm not your attorney for everything. I know you have a criminal case right now. I know you're going through a divorce and you've got a family law case. I'm only doing this immigration piece, right? And then even where if you ask me to go to family court as your immigration attorney, because you're concerned about how things, pan out in family court and how it might impact you as a non-citizen, that's also going to be time that I'm lawyering, but don't expect me to stand up in court and talk. I'm saying that just because that actually happened. And I was like, I'm not here to do the family law part. I'm here to do the immigration. See, one more thing is unauthorized practice of law. I want to mention that this comes up a lot for us, especially because, in a lot of Latin American countries, folks who are sort of they are attorneys, and they're even super attorneys with more powers than regular attorneys, are referred to as notarios. And so when a lot of people come to the United States from the South, they may see these advertisements for notarios, or what we call notary publics in the United States. And there's an assumption that these notarios here in the United States have the same, are attorneys and have those sort of super attorney powers that notarios in Latin America have. However, of course, we know that that's not true at all. Notarios are like notary publics, not to put down notary publics, it's a valuable service, but they are not, prepared to represent people in immigration court, and some in fact actually abuse that misunderstanding. I want to ask you, Melissa, if you will answer a question. California Lawyers for the Arts is asking, is there a role for mediators in any of these scenarios?
Absolutely. And so I think probably mediation is not to have it as like the last point that we make, but certainly these cases are highly complex. And, there's a lot of concerns. The law changes very frequently. There's a lot of unanswered questions at how all of these issues overlap legally. We haven't had cases that addressed all of them in a way that gives us a lot of clarity as lawyers for advising our clients. So the best, perhaps, way to deal with this is to amicably resolve these cases. Mediation is a third-party dispute resolution process. You have a neutral individual. In the United States, in almost all parts of this country, it's also confidential, meaning it's private. You don't have to worry about the mediator going into court and testifying. And unless there's narrow exceptions to the confidentiality, usually related to whether or not someone is being threatened to be harmed, but you don't necessarily have to worry about going into the mediation process. And if you are not documented, having that then all of a sudden being disclosed or having that, be a problem or an impediment. You can have a lot more creativity in these sessions, but you also need competent legal counsel. These cases are really highly technical, and mediators, even if they are lawyers who are mediators, cannot give legal advice and advise individuals in these cases. And if these cases touch upon multiple jurisdictions and any agreement that comes out of mediation needs to be enforceable in multiple jurisdictions, you're going to need lawyers, and you're going to need probably multiple lawyers, immigration lawyers, maybe criminal lawyers if there's criminal implications, lawyers dealing with custody, lawyers in both jurisdictions that you're dealing with, the United States and whatever the other country is, in order to get the best, most robust understanding. And of course, for a lot of families, that is just unattainable. It's just way too expensive. Mediation will certainly be a lot less expensive, though, than if you had to litigate each and every one of those cases in all of the multiple countries. So, it's a definite positive process. It's something that a lot of families can and should use. It's not always clear where you go to find the most competent mediator, unfortunately. Fortunately, though, at least a lot of our courts in the United States do have rosters of mediators that can help, and often bilingual mediators, cross-cultural mediators, mediators who have experience working with families from other cultures, religions, different genders, different identities, and those mediators can try to help bridge all of the issues in your particular case. So I think actually that brings us up to our end time.
Yes, and I think we were able to actually weave some of these things around the screen in earlier. I would just say that, in terms of a takeaway, just what Melissa just said about how complicated these intersectional cases are. And I would add just, for instance, like in family law, sometimes the Indian Child Welfare Act comes up, ICWA, and I've seen that come up in a case where one parent is a non-citizen from Mexico, another parent is a tribal member in the United States. And so now not only do you have the immigration issues, not only do you have the state family court issues, but you also have to consider ICWA and the child's rights under ICWA. And, in terms of indigenous migrants and the Declaration on the Rights of Indigenous People. So there are, it gets very complicated. So please don't understand that each case is case by case basis, and it doesn't matter what happened 5 years ago to your neighbor or whatever. Please make sure to get the right type of advice, or if you're an attorney, to seek the counsel of attorney experts in the area that you are not familiar with.
Melissa and Carolina, thank you so much. I think that the information and the way you provided it today was so accessible. I know there are folks in the audience who are doing this work, and I know that this provided so much information, and just even like hearing you all go through these kind of scenario-based cases, it's kind of like, can't imagine how complex, it can get. And so just for the folks in the audience, and to the two of you, thank you for the work that you do, because I think it's so important and powerful. And we're just so grateful that we could have you present with us today. I know that in this short amount of time, there was so much that we probably didn't even get to touch upon in this complex topic, but I really appreciate the depth that you were able to go into. I learned so much just sitting here listening and trying to absorb it all. So thank you again for your time, Melissa and Carolina. For those of you that would like to contact them or reach out, their information is on the screen. Screenshot it, and you can always reach out to us as well at California Lawyers for the Arts. Thank you all so much for your time.